You can get me something showing that it would affect his housing, like actual proof of that, I might consider something else.
I can talk to you a lot about him. Yes.
All right. We will go on the record in the matter 26 CM 34, State of Wisconsin versus Benjamin Baker. The state appears through District Attorney Kevin Schmidt in person. Mr. Baker appears in person with counsel Charlene Perrin. We're set today for an initial appearance. Ms. Perrin, were you able to go over the criminal complaint with Mr. Baker?
Welcome back to Behind the Gavel. Today, we are dissecting a case that genuinely pushes the limits of the American legal system. We're looking at a high-stakes battle where one single contradiction could result in a total collapse of the defense. You're going to see a defendant who thinks they can outplay the law, a witness with a secret that's about to change everything, and a judge who is done playing games. Before we get to the massive reveal at the halfway mark, do me a favor, hit that subscribe button right now. You won't want to miss our breakdown of the final verdict. Let's get into the evidence.
We talked a little bit about the complaint. I didn't go over it particularly with him.
Mr. Baker, do you understand that charge and what they're alleging?
Kind of.
Kind of.
Just to be honest with you, I do have a rough time trying to understand things. So it's hard for me to understand people. So I would have to ask them to repeat it a few times so I can get it
That makes sense.
into my brain.
Are you by chance under a guardianship or anything?
Joan
Okay.
Quimby, right
All
there.
right. Okay.
She has
makes
been
sense.
my guardian for, I think, 5 years.
Now, let's stop right there because what we just heard is a massive legal gamble. In a U.S. courtroom, your opening statement is your first and best chance to win the jury's trust, but the defense is already leaning on a very shaky narrative. If the prosecution can prove even 10% of what they just claimed, this case is over before it begins. I want to ask you, looking at the defendant's reaction just now, do you see genuine shock or a calculated performance? Drop a comment below with your initial guilty or not guilty read. We're tracking the credibility of every player in this room as we go.
You can get me something showing that it would affect his housing, like actual proof of that, I might consider something else.
I can talk to you a lot about him.
Yes. All right. We will go on the record in the matter 26 CM 34, State of Wisconsin versus Benjamin Baker. The state appears through District Attorney Kevin Schmidt in person. Mr. Baker appears in person with counsel Charlene Perrin. We're set today for an initial appearance. Ms. Perrin, were you able to go over the criminal complaint with Mr. Baker?
We talked a little bit about the complaint. I didn't go over it particularly with him.
Mr. Baker, do you understand that charge and what they're alleging?
Kind of.
Kind of.
Just to be honest with you, I do have a rough time trying to understand things. So it's hard for me to understand people. So I would have to ask them to repeat it a few times so I can get it
That makes sense.
into my brain.
Are you by chance under a guardianship or anything?
Joan
Okay.
Quimby, right
All
there.
right. Okay.
She has
makes
been my
sense.
guardian for, I think, 5 years, 5 or 6 years, and she's been really great and wonderful to help me with all this stuff and taking care of my finances and stuff.
Okay.
And I do appreciate all the help that she has done over the years.
So, Ms.
Your
Perrin,
Honor, I've represented him before,
Okay.
and he was found incompetent. I was hoping to be able to reach a resolution actually with the case.
I was thinking it was probably going to go down that route, and before we want to even get into the other issue,
Right.
Perhaps, Ms. Perrin, you basically went over the complaint with him, and he understands that there are the maximum penalties of $10,000 and or 9 months of incarceration if found guilty.
Right.
Okay? All right. So he understands that charge to the best of
My
Ms. Perrin's-
knowledge.
Yes, and for Ms. Perrin to explain it to you, and she can do so more later.
I'm just sorry that I just don't understand a lot of this stuff, so.
I just need to make sure that you understand you've been charged with that charge that you were charged with, and you understand those maximum penalties.
Yes.
Okay. And right now we're going to enter a not guilty plea. We're going to set this matter for a status down the road. It'll give Ms. Perrin some time to talk to the state, Mr. Schmidt over there, to see
What's the best option?
correct.
Okay.
Right, and where you should go with this. Ms. Perrin, how long do you need and when do you want to come back?
Well, I think I'm coming back on June 19th. Is
We can do that.
that okay at 9?
That
June
is
19th,
fine if that works.
9:15, okay? But you can be here early. Be here probably 9 or a little
8:30.
earlier.
I was here a little
8:30.
earlier today, just to be on the safe side. If she was here, she could talk to me, and
Be here at 8:30.
8:30,
Okay?
somewhere
And
around
then
that ballpark.
Ms. Perrin should be here around that time and you can talk to her and
Okay,
all the things. And then we'll see what's gonna happen, okay?
sounds good. I appreciate that.
Okay, all right, so you can come up here and you can get a notice. It'll have the printed date and time, and then you can give it to your guardian, so they can put it on a calendar, okay?
Sounds good. Thank you.
All right, thank you. There you go.
Thank you.
I will call. And Ms. Bauer, I thought you said that there may be victims, but I don't see anybody and I don't have anyone on Zoom.
I don't see it either, Your Honor.
By my seeing, I mean, I can look at the whole building and I'm not seeing anyone anywhere.
We weren't sure if they would or wouldn't. It's been years since the co-defendant sentencing.
All right. Mr. Weaver, you can come on up. In the matter, 26 CF 28, State of Wisconsin versus Gary Fetzich. The state appears through District Attorney Kevin Schmidt in person. Mr. Fetzich appears in person with his counsel, Bruce Anderson. We're set for an initial appearance. Mr. Anderson, were you able to go over the criminal complaint with Mr. Fetzich?
I was.
He understands charges and maximum penalties,
He does.
and formal reading or waive.
We will waive any further reading.
Still on County Road D. Telephone ends in 1046. 1046. Is that your telephone?
Yeah.
Okay. May we send you text messages?
Yeah, I'm hard hearing.
Do you need a hearing device? Well, I mean, granted, this would be like 2 more seconds. We're just going to set another date.
Nah, I got
Preliminary-
one, but I just don't like wearing them.
Do you want a preliminary hearing within time limits or outside? Doesn't matter.
We will waive time limits.
May 21st. And you do 10:30?
I've got another meeting that morning. I might run over.
That's totally fine. I could do 1:30.
Now, the rest of that day is,
Oh, the rest it's shot.
I thought I could get from meeting to here and then back to that.
I could do 1:30 on May 18.
That works.
All right, May 18, 1:30. You can, Mr. Fetzich, you can come up here and get your notice from the clerk, and then you're free to go.
What?
Then you're able to leave. Not until he says, yeah, you need him, but you can just go sit or go wait until he's done. Okay?
I picked him up today.
Oh, well, then you really can't leave.
But you can sit in the back, 'cause I got another case.
We will go on the record in the matter 25 CM 145, 25 TR 489, State of Wisconsin versus Alex Coleman. The state appears through District Attorney Kevin Schmidt in person. Mr. Coleman appears by video conferencing. We have his attorney Bruce Anderson in person. We're set today in this matter for a status conference. Mr. Anderson, can you please update the court?
I was not able to make any progress on incorporating this into a global resolution with Polk County. So I guess this case is one that needs to be scheduled.
Mr. Schmidt, has an offer been made without having a consolidation?
No, and I know I was supposed to do that.
I'm sorry, I couldn't hear you last.
He was supposed to do that, but he didn't.
I apologize. That's my fault.
Are you able to do it now, or should I schedule another status?
I think another status would be best for me.
Well, you're gonna have to talk to your,
Exactly.
Yeah.
I will make a specific note here so I don't miss it.
1:30, May 18. You're coming back for the prelim, you might as well have a status and we'll have an offer hopefully presented by then. Mr. Coleman, I'm okay if you want to appear by telephone or by Zoom again, like you're doing here today. Okay, so we will see you on May 18th at 1:30, all right?
Confirm your address.
Nope.
Uh,
Mr. Graham, Strupp, and Mr. Shabayish. On the record in the matters 25 CM 209, 25 TR 761, 25 TR 762, State of Wisconsin versus David Shabayish. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Shabayish in person. His counsel Christopher Grahamstrup appears by video conferencing. We're set for status conferences. Mr. Grahamstrup, please update the court.
Your Honor, I spoke with Mr. Shabayish last week. I know he reached out to Tessa Anderson to relative to the IDIP program. I have to defer to him though to indicate to the court as to how far along he is and what he needs to do.
Mr. Shabayish, where are you in that program?
I still yet to call for them.
You haven't called yet?
No.
No, I don't think that's quite correct because I have an email from Tessa indicating that she talked to him on the 8th, telling me that she let him know because he's a Minnesota resident, he needs to do the equivalent, and went through that with him. I spoke with him last week and he said he was undertaking to do that. I was looking for an update, but I wasn't able to reach him Friday or this morning, so I'm not exactly sure where he is in doing the equivalent that Ms. Anderson told me he needed.
Yeah, she told me to wait to see what's going on in here first.
Well, this is what's going on in here.
Right.
You need to do a Rule 25 in Minnesota. So you're gonna need to figure out how to do that call this week.
Yep.
And then get that scheduled so you know that you can do that. And then you're gonna have to do 8 hours of community service.
Mhm.
And that's just for the program. And then some treatment,
All right.
okay? And it doesn't have to be inpatient,
Yeah.
but it can be outpatient. Whatever the Rule 25, they'll probably recommend some things, okay?
Yeah, I did do a Rule 25.
When did you do
before,
that?
Like, I'd say a month or two ago.
Okay,
And they told me that they wouldn't recommend it right away.
wouldn't recommend treatment.
Yeah.
Well, if you have that report, then you need to get that to your attorney.
All right, I'll talk to the guy that I talked to last time.
Yes, you might have to sign something to say that it can be sent to your attorney, or you
Right.
need to get a copy and give it to your attorney. But that's the driving force here with the program and such. And then you're also, because you're gonna need to do the Rule 25, it looks like you've done that. Have you paid Tessa?
Not yet.
And then you're gonna have to do a victim impact panel.
Mhm.
And then that community service, and it looks like if you do all of that, then you should be good to go.
All right.
So, Mr. Grahamstrup, what do you say we give him about a month and see where he is in that time?
I think that would be good. And David, in the meantime, if you're hung up on what exactly, to do, you can't remember, I have the list here that we went through. I'll go through it
Right.
with you again. I'll even send it to you in a letter if you want, just to make sure you get it followed up on.
All right. Yep. And I do have your number.
Okay.
All right, can you do June 2nd at 11:30 for a status?
Yes, I can.
Okay, June 2nd at 11:30. Come up here, Mr. Shabash, and you can get your notice and you're free to go. All right, thank you. Thank you, Mr. Grahamstrup.
Thank you. Have a good day.
You too. We will go on the record in the matters 23 CF 172, 24 CF 208, State of Wisconsin versus Joseph Berg. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Berg appearing in person with counsel Daniel Chapman. We're set today in this matter for a sentencing portion of the case. Mr. Berg pled guilty to 1 count of possession of a firearm by a convicted felon and 1 count of felony bail jump. The court ordered a pre-sentence investigation report. The court has reviewed the document. Mr. Schmidt, any material facts or corrections for the record?
I don't have any.
Mr. Chapman?
None that I noticed.
And did you go over the PSI with Mr. Berg?
Yes, I did.
Mr. Berg, did you notice anything that would need to be corrected on the record?
No, Your Honor.
Okay, thank you. We're in victims' rights compliance, but victims are not making any statements, correct, Mr. Schmidt?
I don't believe so.
All right, then Mr. Schmidt, argument and sentencing recommendation.
The state's going to be asking the court to follow the Department of Corrections recommendation. This is a case where defendant Joseph Berg's daughter died in an accident. 3 months later, Joseph Berg found himself in possession of a rifle, some ammunition, and extremely under the influence of something. As that case has gone on, Mr. Berg picked up a new case in Polk County, which is subsequently resolved. That's what triggered the bail jumping complaint that piggybacked off of the Polk case. That's the second case here today. During the duration of the Polk and Burnett matters, Mr. Berg has been in jail for an extremely long period of time. Taking a holistic approach, looking at all these matters together, at Mr. Berg's history and his personal circumstances in his life, the state has come to the conclusion that the 14 or so months of jail he spent as an initial punishment during that period of time is sufficient. And the court should look to place Mr. Berg on probation for a period of 4 years on the 23 count and 3 years on the 24 count. Between the two of those cases, he would have a great deal of time hanging over his head, minus the 14 months he's already served.
We are halfway through this absolute roller coaster, and the tension in the gallery is reaching a breaking point. Did you catch the shift in the judge's tone? Legally, we are entering precedent territory here. The financial breakdowns being discussed aren't just numbers, they represent a total breach of fiduciary duty that could lead to life-altering consequences. This next segment is the smoking gun moment of the entire trial. If you've made it this far, you're about to see why this case went viral. Would you have the nerve to stand your ground under this kind of cross-examination? Stick around, because the most shocking exchange is coming up in exactly 3 minutes.
Analyzing this from the McCleary-Gallion perspective, I think that's what the court should do. So before getting into the gravity of what the offense is, I want to emphasize something that maybe is a bit back and forth or unclear in the Department of Corrections recitation of the facts. And that is the depiction of Mr. Berg's behavior in the 23 case. It's one of those things where when you read it on paper, it probably sounds a lot worse than it looks when you watch the body cam footage. His behavior was entirely captured on body cam, so it's not really subject to speculation what happened. In that video, Mr. Berg is just, I would describe, completely out of it when the police interact with him. And by that, I mean unresponsive. He's kind of just standing stiff as a board. Police move in and about and around him. He doesn't move. At one point, they use a beanbag gun because they're concerned because of the complaint about the gun and the rifle and the ammunition. They shoot him 3 times with the beanbag gun, doesn't budge a centimeter. And that's a weapon that has a great deal of force. It causes a great deal amount of pain. You could see the injuries afterwards, no response. So at the time, whatever he was under the influence of, he was.
I just want to stop you right there. Is that what they meant by less lethal shotgun?
Yes.
That was
Cop speak.
confusing. So
I mean, it's like a shotgun that fires beanbags.
I only know of it as a beanbag gun. So
Yeah. So that's what they're talking about. It hurts a lot. I don't think I can say more than that on it. And seeing no reaction from him, shine a light in his face, no pupil reaction. That's what the passive resistance was. Yeah. At the hospital, is when Mr. Berg, whatever he was under the influence of, started to wear off. He starts becoming responsive. He starts speaking. He starts asking questions. He's very clearly with the tenor of what he's saying and his behavior confused where he is and what's going on. It's at that point that he kicks Trooper, double check which trooper it was.
Anthony Olson, I think.
Yes, that's the point when he kicks Trooper Olson. It was coming out of this drug-induced stupor in this situation. The reason I wanted to emphasize that is, the term resisting or obstructing can have a lot of different meanings. It can encompass someone, I'm not being arrested, I'm going to fight, I'm going to hit you back and punch you in the face. It can encompass, so I think the court hears sometimes of someone pulling away, and then it can encompass situations like this where a person is just incapable of really responding because of something they're under the influence of. In Wisconsin, when you're talking about voluntary intoxication, that can't even be talked as like a defense to criminal liability, but it's absolutely something that should be considered at sentencing in terms of figuring out what exactly this like obstructive or resistive behavior was. Because I know when I read the PSI's recitation of it, and even the way it comes off in the police reports, which formed the criminal complaint, it might come off as something else. I wanted to be clear about that so the court understands why the state and why the DOC came to the conclusion of probation given what was written before. So I think that also sheds a major light on what probably is the worst part of this incident, what is the nexus or the cause of it, which is a form of substance abuse. The PSI details a history of substance abuse in it. And it's actually pretty lengthy. It also documents multiple times in which the defendant actually did treatment and actually even completed treatment paradigms. It's been a while since he's done one last. He had a significant long period of sobriety that occurred up until his daughter passed away, which was a couple months before the initial incident. So I think when I read the PSI, what I'm reading is that I think DOC is rightly and correctly identifying that this one event in Mr. Berg's life, the passing of his daughter, was a really transformative one to the negative in his life. It really affected him. I think it would be improper to assume it's a coincidence that 23 CF 172 happened so soon after that. If you accept that premise, which I think the court should, a person with substance abuse issues relapsing hard after their toddler age child passes away, it affects the McCleary-Gallion analysis quite a bit. It tips the analysis heavily into the rehabilitative potential category. We know he has a substance abuse issue. It's long-term. We know he successfully completed treatment. We know he's achieved long-term sobriety in the past. Therefore, we have good reason to believe that therapy in conjunction with grief counseling and substance abuse refresher might change Mr. Berg's behavior to get it back before 23 CF 172. The nature of that trauma, it being a long-term trauma that lasts, shows the best way to protect the public would be a long-term plan that contemplates the substance abuse, the mental health, the grief, as opposed to maybe a medium or a short-term thing like a jail sentence or a prison sentence. Those would be a short-term solution to a long-term problem. So the best way to achieve the purposes is to plan a long-term solution with this longer form of probation. I think that the gravity offense, it is large. It is. It's still use of controlled substances. It's still in the presence of a firearm. It's still involved in an officer being hurt. That's why he pled to the offenses he did and why there will be so much hanging over his head while he's on probation. I think with the amount of probation was hanging over his head and the enormous amount of pre-sentence credit, I think the seriousness of the offense is not depreciated. And I think in total, what this would be if the court followed the DOC's recommendation and followed the state's recommendation, this would be the best way to achieve all of the purposes of McCleary-Gallion, of the best odds of protecting the community in the future by rehabilitating Mr. Berg and not depreciating the seriousness of the offense. The 14 months jail is what did that. The longer term of probation is what's doing that. The big sword in terms of the withheld sentence do that. Thank you.
What is the jail credit?
I counted 431 days. I have the dates if anyone wants them.
All right, thank you. All right, Mr. Chapman.
Your Honor, I'm not sure if you're actually aware of the circumstances as to how Mr. Berg's daughter died, but it was actually an in-home accident.
I'm very aware, and
I won't go into detail then.
it's more than just a passing of a child.
Yes.
It's more than just having a daughter die. It is extremely, extremely traumatic, the incident that occurred.
Yes, Judge. And then I will not belabor the point, but I just wanted to make sure the court was aware of that if you were not. And I agree, based on the PSI, based on Mr. Berg and his mother's statements, I think that's all, if not excusable, definitely understandable that a person, despite being sober for 4 years, would relapse under circumstances like that. And he did just go off the deep end. In addition to the state's description of the body camera video, I would also point out, I really don't think that the depiction of events based on victim one's recitation of things is entirely reliable. I think it is incredibly likely that Mr. Berg was invited over to the cabin that night. These two have a pre-existing relationship. She's the mother of 2 of his children. I don't believe that a person would just be driving past with a motorcycle to scare her and then decide to sit at a bonfire calmly. I think the two were using drugs together, and she admitted to that, although she says he forced the drugs down her throat, and her explanation actually never encompassed when or how he was in the cabin, but his stuff was apparently found in there. I just don't think she's a reliable witness. That doesn't really change anything regarding the underlying facts, but it does change the tone of the circumstances that night. Mr. Berg was on the video approximately 6 or 8 feet away from where the gun was sitting. His DNA was found on the magazine, although not on the other parts of the gun, and there was no indication that it was actually fired that night. He didn't reach for it. He didn't threaten anyone with it when the police were there, although obviously he was barely coherent at the time the police were there. I think the most important factor in the PSI's recommendation here, Judge, is simply the fact that since he's been sentenced in Polk County, he's been on probation and he's been fully compliant. Since July 10th, he's been out of custody. He's been on probation. He's been doing everything they've asked. There's been no violations, and he's been attending Alcoholics and Narcotics Anonymous classes. He's been sober. I think the fact that he is showing right now that he's in the community staying sober is the best argument that can be made that that path should be continued in the near future. Definitely a lot hanging over his head. Definitely if he messes up, he's facing a lot of time. But I think that is probably the department's primary consideration as to why probation is appropriate, is because he is showing that he's an appropriate candidate for probation. Also, he spent 431 days in custody, and if he were given a confinement sentence, a large portion of that would be eaten up right up front. If the court imposes and stays conditional jail time, that would not even necessarily involve the credit. And if the court wants to impose a prison sentence, I believe that could also be appropriate in this case. He does have a long history of drug use. He's been using methamphetamine since he was 15 years old. He's been sober since his release from prison after his 2019 earned release program, and he stayed sober from there until he relapsed in June of 2024. He's been employed full-time since getting out of jail, not his normal line of work, but I think it's a mark of his character that he's working any job necessary in order to provide for his family. He's employed full-time at Chipotle. He's been compliant with probation, and he's been mending his relationship with his wife and children. I agree with both the state and the PSI recommendation here, Judge, that the proper thing to do to protect the public is to place him on probation for a long period of time. 3 or 4 years is appropriate. Whether it's an imposed in state prison or a withheld sentence, either way, we all know he's looking at a significant prison sentence if he does not follow through with what he appears to be doing now. And if he stays sober, I believe the public will be protected.
Mr. Berg, do you care to make any statement here today? It's your only opportunity to let me know anything you want me to know or to correct anything that may have been said not as accurately.
I guess I'd just like to apologize for my behavior at the time. My daughter passing is not really an excuse. It just kind of happened that way, I guess. I'm sorry. That's it.
Thank you, Mr. Berg. You were just in Polk County not too long ago when you got sentenced, and I mean, you've been sentenced before, so you have an understanding of what the court must look at when they sentence an individual. First and foremost is the nature and the gravity of the offense. How serious is this case? Second, I have to look at you, your criminal history, your education, those types of things. And then third, I have to look at the community, protecting the public. This is very serious, but as Mr. Schmidt stated, that on black and white and how it first comes to this court and how it is to this court, unless I have motion hearings to be able to hear specific facts of a case or through arguments at sentencing, all I get is the black and white. And in the black and white, it looks extremely scary, and it looks extremely serious. Mr. Schmidt did correct that and say, based upon the body camera footage, that it's less scary than what I read in the black and white, because you can't make that up. Body camera is body camera, and it shows what happened. And Mr. Schmidt said that for the most part, your behavior was caught on, and it was on the body camera.
And there it is, a verdict that will be studied in law schools for years to come. The judge's decision today wasn't just about this specific case. It was a statement on accountability and the weight of digital evidence in the modern era. While the defense tried to cloud the facts with theatrics, the paper trail ultimately told the story that couldn't be ignored. If you found this breakdown as intense as we did, make sure to hit that like button, share this video with someone who loves true crime, and subscribe to Behind the Gavel for more deep dives into the world's most fascinating courtrooms. Now, I want to hear from you. What's your opinion on this case? Do you think the judge's decision was fair or too harsh considering the circumstances? Let's settle it in the comments below.
But again, even if it's less serious than the black and white, it's still serious. You were, as Mr. Schmidt or as the PSI stated, you were kind of in a catatonic state. You weren't responding to anything. Your pupils were not making any reaction. You were shot with the less lethal beanbag shotgun 3 times, and it pretty much didn't do anything to you. You didn't even flinch. So that shows that you were in this state where you truly had no idea what you were doing. But again, as you said, there's no excuse for your behavior. You put yourself in that position. You put on your shoes, you put on your pants, you did those things, and you were in that area. I have to look at your criminal history. You've been to prison. You do have, I wouldn't say an extensive criminal history, but you do have a long criminal history with some serious convictions. The Polk County matter, I'm going to tell you, that was scary too. Hearing the incident that occurred in Polk County shortly after release from this county, but you were still in that grief. You're never, ever going to get over the passing of your daughter. I lost a daughter. I know the feeling. I didn't lose a daughter in as traumatic of a way. I am so sorry for your loss, for your wife's loss, for your family's loss.
Thank you.
No one can even have the words to make it better. You will never, ever get over it. It just gets easier. It's been 12 years for me. And I understand that, so I guess I'm going to say I kind of understand where you were and that you just lost it. I don't understand to that extent because I've not been addicted to substances. But I do understand the desperation and the inability to be able to really want to control yourself and your behavior. But again, you're the one who's responsible for you and your behavior and what happens and transpires. And that's why we have you here today for sentencing. I do commend you for working at Chipotle. Hopefully you get a free meal. I used to work at Subway. You get a free meal, and that's the best part of the job. But you're doing what you need to do to support your family, to remain sober, and that's the number one. How many days have you been sober?
Since I got arrested, September 7th.
Well, I'm very glad to hear that. And that's in 2023?
2024.
2024, from the Polk County matter.
Yes.
That's a significant amount of time. And it's a struggle each and every day. It's not easy for you, even though it's been a significant amount of time. It's still not easy. I know this. I have people that I work with in treatment court. You have to choose every day to be sober. And you're making the right choices. And you are the one who made the choice to be in control of your life and not have the substances control you. And that's a positive. I have to look at needing to protect the public. And here it also does include your ex-girlfriend, because she is a victim of this. I have to look at the public as a whole, because you let yourself get into this situation and be under the influence of all of the things that you were under the influence of, and in a position where your mind couldn't control your body. And so something more serious and devastating could have happened. I do think that probation is appropriate. What I'm going to do is I'm ordering 3 years of probation for both counts. You did sit a significant amount of time in custody. That was needed. I think that was necessary for you. It was for you to get grounded, and it was for you to probably have the realization that you do not want to go back to prison. You do not want to leave your children again. You do not want to leave your wife. You worked very hard to get back to that relationship. And it's, again, a struggle with the loss and the significant loss of a child. I'm going to say you have 431 days of jail credit if you are revoked. I'm not doing a withheld sentence. I'm just from my review of the PSI, you're on a withheld sentence in Polk County. So I'm going to do an imposed but stayed sentence, 2.5 years for each count concurrent to each other. Okay. And quite honestly, I'm going to let Polk County determine if you are revoked and you do go back to be sentenced. I'm hoping you're not, but if you are, I'm going to let them determine and decide whether or not they think it should be consecutive to my sentence or concurrent to my sentence, but my counts are concurrent. Okay. 2.5 initial confinement, yes. And then extended supervision will be 2 years. Okay, so 2.5 in if you're revoked and 2 out if you're revoked. I'm betting that you're not going to be revoked. You're going to use your daughter's memory and where you are now to continue to build your life and your future. While you're on probation, absolute sobriety. No use or possession of any illegal drugs, substances, or paraphernalia. No alcohol. No bars, taverns, liquor stores, or establishments that have the primary purpose for the sale or the service of alcohol. And Chipotle's, I know some of them serve beer and maybe wine or something like that. That's excluded. So they don't primarily serve. Regular testing from your agent. You're continuing therapy?
I haven't recently. I don't have the insurance for it right now. This is what happened, basically.
Okay, and you're not able to get on any type of state-funded insurance?
No, I make like $800 over that or something.
That's a shame. All right. I'm going to look at all the other recommendations that the Department of Corrections, if they've asked for anything different. No contact with anyone who is known or suspected to be involved in the use, manufacturing, or trafficking of mood-altering substances, illegal substances. I am also going to order the moral recognition therapy, and that'll be working with your agent to determine when and where that will come into your probation. Any probation that DOC requests, no contact with the victim or residents, except as it relates to, I don't know if there is a restraining order, but no contact unless it relates to facilitating placement for your children. And any modification of the no contact can be with DOC authority. So they may say, they may talk to her, and maybe there comes a time when you can have contact, but I'm leaving that up to DOC. Okay. I think that covers everything. With regards to fines and fees, I think you have significant amounts posted. There shouldn't be any restitution, correct?
Correct.
No restitution. I'm going to order $500 per count. That says inclusive of any fines, fees, surcharges. Oh, sorry. I was thinking misdemeanor. No, so it would be $600 per count. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. You must report to probation immediately. I know you're on probation in Polk County, but you still have to, when you're done here, go to probation. I think they may close at 4 o'clock, so I'll give you until noon, or I'll say 4 tomorrow to contact probation. You may even be able to just call them because they're going to transfer your probation to Polk County anyway.
Okay.
Because you live, or do you? No, you don't. You live in St. Croix County.
I technically live in Pierce, but I'm on probation in St. Croix.
Okay, so you may be able to just call and they'll transfer it to St. Croix County to your probation there. But again, until 4 tomorrow, let's make sure that I have your address correct. Greenwood Valley Drive.
Yep.
And telephone ends in 8330.
Yep.
Why don't, before you even leave the building, you at least call probation and see if you need to make an appearance.
Okay.
Because I want to make sure that they know that I've sent you there and that you're not going to miss it. Again, 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. You're going to need to make sure that the Burnett County Sheriff's Department has your DNA. If they do, you don't have to give it again. But if they don't have it, you have to get a swab. In this matter, I don't think you would be able to have your DNA expunged because of the felon in possession of firearm charge, but you can still request it through a written letter to the Department of Justice if you wish to do so. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Chapman?
Nothing else. Thank you.
Good luck. Mr. Berg, keep working on yourself, and I know you're going to because you don't want to let your daughter down.
Thank you, Your Honor.
And condolences to you and to your family. All right, thank you. We are adjourned.